Good afternoon, ladies and gentlemen. I'd like to welcome to you to this afternoon session. My name is David Kirkham. I'll be the moderator, and we are going to talk about the Respect for Marriage Act and its implications for protections for religious institutions and maybe a little bit for individuals as well. This act went into effect this past December, and it added religious freedom protections to federal law concerning marriage. Unprecedented in that regard. And to discuss it with us today, we have brought together a team of reconcilers, peacemakers, litigators, advocates, teachers, all who have been greatly involved in this. We are going to start with, sitting on my left, we'll hear from Tim Schultz, who is the president of the First Amendment Partnership. He will be followed by Tyler Deaton, president of Allegiance Strategies, Senior Advisor for the American Unity Fund and American Unity PAC, and founder and Senior Advisor of Freedom to Believe. And I think those two have been very much involved in this from the ground up. We're going to give us that backstory that is so rich and intriguing and talk about why it has become successful. And then they will be followed by Jean Schaerr, who is managing partner in Schaerr, Jaffe, and professor of law, J. Reuben Clark Law School, and a senior fellow at the International Center for Law and Religion Studies. And I just can't help this. It's kind of a coincidence, but Jean Schaerr was a freshman on the floor of the dorms when I was just a little older than that, living in the same dorms as I was. So this goes way back. I know we can trust him. Anyway, with that, I turn the time over to Tim, please.
Okay, well, hey, it's great to be with you and to see so many friendly and familiar faces in the room. And I have been the president of the First Amendment Partnership for a little over a decade. And my organization works with faith groups to try to pass laws that protect religious freedom. And I am going to be talking about a little bit of the political backstory to the Respect for Marriage Act. And why at a law conference would I talk about the political backstory? Well, let me tell you why. It's because ever since the Employment Division versus Smith decision in the early 90s, many of the religious freedom protections that we enjoy are due to statutes or lack thereof, right? It's not all constitutional law, or, it's a lot of it is statutory law. And the most famous addition of that is when Congress, in response to the Employment Division versus Smith case, passed the Religious Freedom Restoration Act of 1993, right? That's a famous example. Of course, a few years later, the Supreme Court came back with a case called City of Bernie versus Flores and said states, if they want that kind of level of protection, are going to have to pass their own state religious freedom restoration acts. So because so much of the religious freedom we enjoy is statutory, it's really important to understand the political context, because that not only explains the past, it also sometimes portends how durable these protections will ultimately be. And I'm going to talk about the political backstory of the Respect for Marriage Act. But before I do, I want to say this. For those of you who didn't sort of follow along with the RMA, people who were insiders to this, and I think we would all three agree with, we were sort of all insiders in the discussion, would say that the Respect for Marriage Act is first the most important religious freedom protection passed by Congress in a generation. That is, since the Religious Freedom Restoration Act itself in 1993, so in nearly 30 years. It's also the first gay rights legislation passed by Congress since 2010. That was the repeal of the Don't Ask, Don't Tell provisions. And I would say that at least in modern history, it's the highest degree of difficulty religious freedom legislation probably ever passed. RFRA, of course, passed almost unanimously. The Respect for Marriage Act was a high-wire act. It got across the line barely. And so as such, it's also a big political victory. Now, something like this doesn't just fall from the sky, right? It kind of appeared to, because it just sort of seemed to materialize and then to happen. There wasn't a lot of buildup, but it didn't just happen. And for those of you who like TV series, you know how sometimes like in a new season of a show, they'll kind of go back to the previous season and they'll start the new season with like a montage of kind of what happened. That's what I'm going to do here. I'm going to give you a montage of developments that sort of explains everything kind of headed up to the summer when the Respect for Marriage Act ultimately passed. Okay, so I'm going to run through this very quickly. In 2013, state religious freedom restoration acts, after a several-year hiatus, start to be passed in several different states. In that year, Kansas and Kentucky passed state RFAR laws. And the interesting thing about them is they were very bipartisan. About 98% of Republicans voted for them, and about 65 to 66% of Democrats in those states voted for them. That's pretty impressive bipartisanship, especially kind of given our current political moment. That same year, the United States Senate passed a law that didn't pass the House, but the Senate did pass a law called the Employment Non-Discrimination Act. That was a law that would have granted non-discrimination rights in employment to LGBT people. It also, though, included an amendment that included quite robust protections for religious freedom. That passed with every member of the Democratic United States Senate voting in favor and about a dozen Republicans voting in favor of it. And then toward the end of 2013, the state of Hawaii became the final state to voluntarily legislatively pass same-sex marriage. This is before the court sort of ultimately took that issue over. But in 2013, the state of Hawaii passed this in November of 2013. But what they did, and what was then the most democratic state legislature in the country, is also pass robust protections for religious freedom. So kind of we exit 2013 thinking, religious freedom is doing pretty well. It's pretty bipartisan. We're feeling pretty good about ourselves, even in the most hot cultural conflicts like those with gay rights. What happened? Well, in 2014, that bipartisan consensus all collapsed. In 2014, there were 7 different states that held votes in one chamber or the other on state religious freedom restoration acts. Okay, remember, there had been several the year before. Now there are several more in 2014. Remember the year before I had said 67% of Democrats had voted for them? The percentage in 2014, just a year later, except in the state of Arkansas, the percentage had fallen to 0. 98% of Republicans still supported it, but 0 Democrats supported it. What had happened? Well, in general, the issue of LGBT rights versus religious freedom had become highly controversial, such that religious freedom laws were seen as a hostile response to LGBT rights. That's what had happened. And so the issue was no longer bipartisan. It was very hard to pass religious freedom laws. It wasn't impossible. My organization kind of shifted ground and tried to pass other laws, but big laws like religious freedom restoration acts were really impossible to pass unless you just were going to say, hey, this is just going to be Republicans and we're just going to pass it that way. There was a real big fork in the road in 2015 that I think explains kind of the modern moment. Many of you may remember the state of Indiana passed a Religious Freedom Restoration Act, which caused really Mike Pence to become nationally famous / infamous because of the political fallout around that law. The very same time, to quite a bit less fanfare, and those of you from this state will know, Utah passed a law that later became known as the Utah Compromise. Non-discrimination rights for LGBT people in employment and housing, alongside robust religious liberty rights. It was praised by a lot of religious liberty law scholars, praised by then President Barack Obama, certainly something my organization thought was a great idea. But it was something that passed and I think has worked very well in Utah. But a lot of people pointed to Utah's unique religious and political culture as saying, well, that might be something that only really works in a state like Utah. And frankly, advocacy groups on both the right and left kind of were both seeking total victory. They weren't seeking compromise. People on the left said, you know what, we kind of did that because we had to, but we're not really seeking to replicate that elsewhere. And people on the right said, we don't want to grant even 1 inch to LGBT rights. When I say this, I'm giving broad generalizations, but that was the general tenor of how the political debate played off. However, there were a lot of religious groups who sort of looked at what happened in Indiana and looked at what happened in Utah, who were not part of the Church of Jesus Christ of Latter-day Saints. And they said, you know what? That thing in Utah looks a lot more attractive to us than that thing that happened in Indiana. So a lot of groups, Orthodox Jews, Seventh-day Adventists, various evangelical organizations like the Center for Public Justice, the National Association of Evangelicals, the Council for Christian Colleges and Universities, as well as, of course, the Church of Jesus Christ of Latter-day Saints, got together and sort of started to engage with LGBT advocacy groups and say, is there any way we can duplicate Utah at a national level? And in late 2013, Congressman Chris Stewart from Utah introduced in the House of Representatives the Fairness for All Act at the federal level. Now, everybody involved with it knew that it was really aimed at changing the debate. It wasn't probably going to pass in that form. The whole point was to sort of move the political center of gravity in a more reasonable way. That was the point. And obviously, it was attacked by both the left and the right. The question is, was that project really going to lead to anything other than just making a few people kind of feel good about themselves? Was it going to lead to anything tangible? And I would say that the answer to that is yes. I think the RMA passed because for the last 7 to 8 years, there has been a group of people on the left of center and the right of center looking for practical both-and solutions. So there you go. That's the backstory. I'm going to come back and talk a lot in the Q&A, but that's sort of the backstory from 2012 going up to the summer of last year.
Perfect. Thank you. Tyler.
Thank you. My name's Tyler Deaton. I run American Unity Fund, and we're a center-right, pro-gay, pro-trans, pro-religious freedom organization that was founded really in 2010 out of an experience in a couple of states in the Northeast where state legislatures were trying to move the freedom to marry itself as legislation. This is we got to go back in the time machine to 2009, 2010, to whenever marriage was nowhere near the law of the land, didn't know that there'd be Supreme Court wins just a few years down the road. And so we founded this effort preparing for a generational fight to win the freedom to marry. I'm gay. I'm married to my husband. We met as freshmen at Wheaton College, which is a conservative Christian school in Illinois. And, you know, I just remember how I felt in 2008, 2009, just kind of wondering if I'd be able to legally marry the man who I loved. And the Respect for Marriage Act, in the thick of the fight to pass that law, that was like the first time that I'd felt that way in a long time, because we just started winning. And I guess it's one of the things that I wanted to share is that the way that we started winning is that this conservative group, American Unity Fund, started lobbying Republicans to support the freedom to marry and started lobbying Democrats to support religious freedom. And it's what we started doing from the get-go. And so you look at the RMA, and really the RMA has a lot of language that's in a lot of state-based marriage statutes, including ones that we worked on in New York and New Hampshire that had these same kinds of protections for pastors, for houses of worship, conscience protections. You know, there's a professor at the University of Illinois. Her name's Robin Fretwell Wilson. She should be here. She's such an expert on this. She has a chart, and it kind of can show you like which states had which protections. And there toward the end with Hawaii, I mean, you really started to get every single thing. I think there are like maybe 12 components that you really wanted to protect religious freedom. And by Hawaii and Delaware and some of those later states, we started to have all of those. But so then, you know, you have the Windsor case, you have the Obergefell case, and then you have the Bostock case, which we've not mentioned yet, but is this case authored by Justice Gorsuch, conservative justice, that said that gay and trans people are protected in Title VII, our federal employment law. So that happened after Obergefell. And then you have Dobbs. And you have this one line in one of the concurrences that says, authored by Justice Thomas, that says, you know, and what does this mean for marriage? And that's the line that launched this entire most recent effort. We would not have had the Respect for Marriage Act unless I think that line had put some focus on the question of marriage. And like, obviously, there's some constitutional tensions. I'm not a lawyer. This is all above my head. But it obviously, you start to see, like, maybe there's something going on with substantive due process, and maybe there's something here that Congress is going to need to wrestle with. Well, it was the first time then, from 2008 to then probably 2022, that I had really started to think again. It's like, well, like, that's crazy. Like, they're never going to reverse marriage. But when it's personal to you, you take an extremely improbable scenario much more seriously. And that's if you're just a good faith critic, right? Turns out Congress is full of people that are not good faith actors. So after yeah, shocked. So after that line, you know, and it's really a throwaway line in a concurrence, whatever. There's a congressman in Upper West Side, New York, named Jerry Nadler, who is just a screaming liberal. And he was in a primary with another member of Congress named Carolyn Maloney, who really represented the Upper East Side. But there was this huge fight over the district lines in New York. They got drawn in together. So now you had this congressional district that jumped across Central Park. Carolyn Maloney ran a horrible campaign, but Jerry Nadler saw this line about marriage. It happened in the summer. They have a late primary in New York. And he's just like, hey, I might file a bill and I might be able to run a campaign on marriage again, right? Like this, everybody would have thought it was a dead issue after Obergefell, but this one line, all of a sudden everybody's paying attention again. Jerry Nadler files a bill. It's unrecognizable from what I think we just passed out. Completely unrecognizable. I mean, there might be like 3 words that are the same from what ends up passing Congress and is signed by the president, but he gets this ball rolling that we need to protect marriage. So our effort sees this. We're just like, yeah, we agree. And we know how to do this. We protect marriage and we protect religious freedom. And so again, I'm not a lawyer, but I just want to talk then a little bit about how a bill becomes a law, not in like the Schoolhouse Rock way, but just like how it happens now in like 2022, 2023, where it turns out nobody really wants to pass anything. Jerry Nadler wanted a bill so that he could raise money and beat Carolyn Maloney. And then I have to just tell you, I mean, and this is no offense, but there are a lot of people on the far right who love it just as much. Like, yeah, file that bill. In fact, file something crazier and we'll raise money off of the opposite of that. And you have, I think, then the good faith actors looking at this and like, actually, this is an opportunity to do what we know how to do and protect marriage and protect religious freedom together. And so I think born out of the experience in Utah, which Tim mentioned, passed the Utah Compromise in 2015, but itself was a journey that goes back to 2008, which itself goes back to, you know, decades before. But if you look at these moments in time from, you know, I wasn't part of it. I'm from the South. I'm not from here, but I came out here for some of these meetings in Utah at the beginning of early conversations between lay leaders in the Church of Jesus Christ of Latter-day Saints and some of the local gay leaders talking like, how do we find common ground? And I really do trace the success of what ultimately becomes, and Gene's the one who's going to tell you why this law is so great. So until you hear from him, take my word for it. But the law that embodied those same values of religious freedom and personal freedom, the freedom to marry specifically, it really is a through line that goes all the way back to some of those early conversations in Utah where gay people and people of faith, many of whom are the same people, but in this instance, you know, some people are at the table advocating for one piece and other people are at the table advocating for the other piece primarily. That has grown now to a national movement that includes a lot of other LGBT advocates. It's a little easier for me to do it because I'm already a Republican, I'm a conservative. It's a lot easier. My organization is funded by Republicans. Like, it doesn't take much for me to go against the grain, but you wouldn't believe, or maybe you would believe, or maybe hopefully you believe me as I tell you, but we've now recruited statewide LGBT groups all over the country, especially in purple and red states, that have joined in this effort so that it's not just Utah. It's not just like your typical conservative gays. It's a lot of people across the political spectrum, across many faiths coming together. And that's how we finally passed a bill through Congress that Gene's going to tell you why it's so great. And then we'll go back to questions.
Thank you. Gene, please tell us why it's so great.
Well, it's great in my view because it's not perfect, but it's very good because it protects religious liberty in a whole range of situations, and it does that for both institutions of faith, like the church and BYU, whose campus we're on right now, but also for individuals. And it's a very simple law. I passed it out to everybody. Hopefully everybody has a copy of it, or at least has the ability to see it. It's just the front and back of one page. And if you just read it, you can pretty quickly understand how robust it is in its protections for religious liberty. If we just start, for example, with under Section 2, which says findings, if you look at the second paragraph, it says diverse beliefs about the role of gender in marriage are held by reasonable and sincere people based on decent and honorable religious or philosophical premises. Therefore, Congress affirms that such people and their diverse beliefs are due proper respect. Well, you might wonder, how in the world did that get there? I can tell you it was not in Jerry Nadler's original bill. But, the way this provision came about is, some of us were talking on a Zoom call, and we said, well, if the other side, and that's Tyler's side in these negotiations, but our thought was, if the other side wants to codify Obergefell and, into federal statutory law, we ought to be codifying the whole thing. And to me, one of the key portions of the Obergefell opinion, which I had worked on very hard as an advocate during that case, I had responsibility for organizing the amicus briefs that were submitted to the court. And one of our objectives there was to be sure that if the court did rule against the constitutionality of state traditional marriage laws, that they would at least recognize the religious freedom issues that were involved in doing that, and that the court would break the analogy that the other side, not Tyler, but some other folks on the left, were trying to make between people who have traditional views on marriage and sexuality and racists, right? That was the narrative was, if you believe in traditional marriage, you are akin to being racist. And so we wanted to be sure, and there had been a couple of pretty prominent judges around the country in invalidating specific state marriage laws that had bought into that narrative and had basically said this is just irrational to limit marriage to man-woman unions, and it can only be explained by prejudice. Therefore, it's like racism. And so that was one of the main objectives in Obergefell, recognizing that that the court was probably going to do what it ended up doing was to get them to do it in a way that was at least respectful of people on, what I viewed as my side of the debate. And so this provision actually paraphrases what Justice Kennedy said about people with traditional beliefs on marriage. He very clearly rejected the analogy to racism and said, no, this is not like that at all. We're ruling against the interest of this group of people, but we are also recognizing that, that they have legitimate, well-grounded moral and philosophical and religious reasons for believing as they do about marriage. And so why is it important to have that finding in a federal law? Well, it's not technically binding on anybody, but it does destroy or seriously undermines the narrative that that people with traditional Judeo-Christian beliefs on marriage are akin to racist, and therefore makes it much more difficult for a future Congress or a state legislature to do anything to enact legislation that's sort of premised on the idea that traditional Judeo-Christian beliefs are akin to racism. Right? Because here you have the Congress of the United States, including every elected congressional Democrat, signing on to a document that rebuts the narrative of, that this is akin to racism. Okay? So that's one very important protection, and it protects both religious institutions and individuals. And then if you turn the page and you look at Section 6, there's a provision with Section 6 is entitled "No Impact on Religious Liberty in Congress and Conscience," and subsection A says, as you can see, nothing in this act or any amendment made by this act shall be construed to diminish or abrogate a religious liberty or conscience protection otherwise available to an individual or organization under the Constitution or the United States or federal law. Well, why is that important? Well, just by way of background, people in the progressive camp have been trying for some time to essentially repeal a very important federal law called RFRA, the Religious Freedom Restoration Act that we talked about earlier, as to LGBT issues. Okay, that's what they tried to do in the Equality Act, which passed Congress. You know, every congressional Democrat, as I recall, voted for that, and you know, and if the Senate could make decisions by majority vote, it probably would have passed the Senate and been signed by the president. And that's also what's going on. Another piece of legislation that was just recently reintroduced in Congress called the Do No Harm Act. It would essentially repeal RFRA as to LGBT-related issues and a number of other things. So what this provision says is that this law does not repeal RFRA as to as to what it applies to. So what and in so doing, it actually reinforces the idea that RFRA should apply in these kinds of situations. So if BYU, for example, were sued over its policy limiting married student housing to man-woman couples, for example, if BYU were sued over that under federal law, it would have lots of defenses, as Steve Sandberg will tell us. But one defense that it would have is, well, that's contrary to RFRA, and this provision makes clear that BYU would be able to assert RFRA as a defense in that kind of a situation. The next provision, Section B, I'm not going to read it in great detail, but it says basically that nonprofit religious organizations and their employees, by the way, cannot be required to provide services, accommodations, advantages, facilities, goods, or privileges for the solemnization or celebration of a marriage. So what that means is that if a couple, a gay couple comes along and says, we want to rent the Wilkinson Center ballroom for our reception after our wedding, BYU can say no. That would be inconsistent with our religious beliefs about marriage, and BYU would have plenty of legal arguments to make there. But this provision makes clear that the Respect for Marriage Act cannot be used to force BYU to do that. So I'm focusing first on the benefits to religious institutions, and we'll talk about individuals in just a minute. And then, if you look at Section 7, it says no impact on status and benefits not arising from a marriage. And what that does is it ensures that institutions and individuals cannot lose any federal benefits as a result of their beliefs and practices with respect to marriage, including tax-exempt status. Now, why is that important? Well, ever since, long before Obergefell, there's been a movement in the progressive camp to try to do what they call Bob Jonesing institutions that they view as quote, non-affirming. That is, institutions that hold to traditional Judeo-Christian beliefs about sexuality and marriage. And and there was even a question during the Obergefell decision about if we rule that traditional marriage statutes are unconstitutional, isn't that going to put the tax-exempt status of a lot of religious institutions at risk? And the United States Solicitor General, who's a very smart guy and a good friend of mine, paused and said, "Yeah, Justice Alito, that's going to be an issue. Yep, that's going to be an issue." And so And so this provision takes that away. It makes clear that an organization cannot lose its tax-exempt status, for example, based on its teachings and practices with regard to marriage. And so lots of benefits for religious organizations, but one of the things that we heard when we were, and my time is up, so I won't go into detail about the benefits for, right now, at least for the benefits for individuals, but there are corresponding benefits for individual people of faith as well in the law. It's well balanced in that regard.
I'm actually hoping you will get a chance to address that, Gene. There are, and I'm hoping that we're going to be able to give time to all of you. That's the intention, but there are a couple of natural questions that flow from this and even questions that were posed beforehand. One, I'd like to give Tim an opportunity to address the Religious Coalition and the Act. That one flows from what we've already been saying. So.
Yeah, I mean, so as Tyler made clear, the Religious Coalition that I work with wasn't responsible for the Respect for Marriage Act's origination. That really was Gerald Nadler. That bill, though, passed the House of Representatives during the summer with 47 Republican votes and no religious liberty protection. So the groups that I work with, again, I name dropped a lot of them, and they all hold to, again, what I'd call the traditional understanding of marriage. They kind of had to make a decision. Are we going to work with senators to add religious protections to a bill that looks like it's pretty likely to pass on its own? Or are we just going to try to fight this to the death? And I think they made the wise decision to say, we're going to engage on these religious liberty questions. We're going to see how much religious liberty we can get here. And many of them would say, we didn't even take a position on the underlying marriage aspect of it. I mean, they all hold in one way or another to the traditional understanding, but they all did say these religious protections are real, they're meaningful, and they're important. And that, of course, ended up being pretty important to the Republicans who voted for it. I would say that was decisive to the Republicans who voted for it. So,
and some of the Democrats.
Yeah, and some of the Democrats. And I would say I mentioned that there had really been about beginning in 2014, I said that we had lost bipartisanship on these issues. Religious protections were portrayed by people on the left as a, quote, license to discriminate, as anti-gay bigotry themselves, right? And that had been the way it had been portrayed for about 8 years by people in the progressive camp, overwhelmingly. And so this is every Democratic member of the Congress, every single one, voting for the proposition that this is not bigotry and voting for real and meaningful religious protections in the most controversial cultural context we have, after 8 years of saying something different. And so that's part of the reason I thought this was so important, that you have reset the balance to a bipartisan understanding that people with traditional understanding of marriage deserve protection in the law.
Thank you. And then just one other question originating from me that just has to be asked, because I know that many members of the audience here, if they don't get an answer to this, will maybe leave not completely fed. And that is, what are the implications for this for this institution, the Church of Jesus Christ of Latter-day Saints, and its corollary institutions and so forth, that have a strong tradition and teachings of family values, traditional family? Start with you, Gene, but we'd be interested in hearing any of your just thoughts on those.
Yeah, well, for anybody who read the papers after the church's position on the legislation became apparent, you would have thought, at least from some circles, from people on both the left and the right, you would have thought that the church was somehow backtracking from at least some of the principles of the Proclamation on the Family, especially support for traditional marriage and that sort of thing. I mean, there was some confusion when some newspapers falsely claimed that the church was supporting the bill. In fact, what the church was supporting and working to get enacted were the religious liberty protections that we've been talking about. But in my view, and I'm one who's sort of been involved in the trenches in these battles for some time, and my wife will tell you we've made some significant sacrifices in support of the church's proclamation on the family, as we understand it. But in my view, this legislation actually facilitates the church's ability to to further those principles that are in the Proclamation on the Family. You know, after the Obergefell decision, as a legal matter, the game was up. You know, notwithstanding Tyler's concerns, there's no way the Supreme Court is ever going to reverse Obergefell. You know, the fact that was just a suggestion in Justice Thomas's sole opinion in Dobbs, and other justices made quite clear that they didn't agree that this meant that Obergefell was now up for grabs again. And the reality is that the Supreme Court will not reverse a prior decision if there are substantial reliance interests that are implicated by that decision. You know, and today you have hundreds of thousands of couples like Tyler and his husband who have gotten married and arranged their most intimate relationships in reliance on the court's decisions. And there's just no way that the court's going to reverse that. I doubt that even Justice Thomas, if pressed, would reverse it. And so, but after Obergefell, the legal landscape had definitively shifted, and I think the leaders of the church were wise to recognize that, and I think there was a shift, and this is pretty clear from public statements by President Oaks and others. There was clearly a shift to saying, okay, well, to the extent that we were in a legal battle on marriage, we've lost that battle, and so the best way that we can preserve and protect and advance the principles in our Proclamation on the Family is to preserve our ability to teach those principles and to act on them ourselves, and to preserve the ability of other like-minded faith groups like the Seventh-day Adventists and the Catholics and the Baptists and many others. The most important thing we can do now to advance those principles is to preserve the ability of ourselves and like-minded religious groups to teach and act on those principles. And the Respect for Marriage Act does that. You know, it doesn't do it as completely and as perfectly as as one might like, but in politics is the art of the possible, and in religious liberty, the gains are almost always incremental rather than stunning, right? Most of the gains are sort of, singles and doubles. And in my view, the Respect for Marriage Act, it's not a home run or a grand slam, but it's a really good triple. And and so when you can get a good triple in baseball, you're going to take it rather than sitting in the dugout and waiting for an opportunity for a grand slam. And
I want to add, as the non-church, well, Tim's also not a member of the church, but from my perspective, this was not in conflict at all with your theological views. No. I think that what we did here, because, by the way, this tax question, tax exempt status, this is something that people on the left would dismiss. They're like, oh, that's not serious. We're not really going to come after your tax exempt status. We're like, okay, well, then why not protect it? But then I was having this same question with people on the right who were like, we're never going to overturn Obergefell. And I'd say the same thing. Well, then what are you afraid? Why not protect it? Like, what's going on? Like, there's obviously something else going on. But It was one of the smartest bills, I think, to pass in a generation. And the reason why I don't think it conflicts and, in fact, somewhat protects your views is that now for generations, your views on marriage are protected in black letter law. My marriage and marriages like mine are also protected in black letter law. We all got exactly what we actually needed. There's no political fluff. People got what they needed. And I think that goes back then to the original thing that started here in Utah, which is you really start to find common ground when you talk about what you actually need. And when you start to just let all of these other political desires dissolve away, and you're like, actually, gay people need jobs, and trans people need homes, and religious people need to be able to go to church and not have the government all up in their business. These are core needs that we all have. Yeah. So I just think that I can't comment on the theology. I think I've read the Family Proclamation, but I don't know it, obviously. But what I can say is that there's something here that the Church of Jesus Christ of Latter-day Saints was willing to do to engage with this process on a bill that, by the way, might have passed anyway without a change at all. Could have happened. I mean, and at one point, there were a lot of us who really thought after we got 47 House Republicans, we were like, the Senate, you need 10. Ended up getting 12. We'll never know. We'll never know what it would have gotten in its original form in the Senate, but why take that risk?
Right.
And the church, and a lot of others, but I think especially among religious organizations, the Church of Jesus Christ of Latter-day Saints saw that and said, why accept that risk to our views? It'd just be crazy when we could engage and protect ourselves, lose nothing, gain a lot. And I think that was just so smart. I mean, politically, that was just a brilliant move by the church to engage on that. But it still, I think, goes back to something that's been happening culturally here that is unique, but is now starting to take root, which is that LGBT people and people of faith are working together more and more, even as you see huge polarization. This is like one of the only areas in politics and in culture that I see people meaningfully coming together in the middle. And I don't think that would be happening at all without the church and members of the church.
Yeah, so I was going to say it's not so much on the theology point from even a legal or theological point. It's sort of like a citizen point that I think the Church of Jesus Christ of Latter-day Saints has really led on finding common ground with people who disagree with them. They do that all the time with respect to religious freedom. The Religious Freedom Coalition I work with, to say the least, has some significant theological differences, right? I have significant theological differences with the Church of Jesus Christ. We work together almost every day, right? So the church has led on pluralism within religious freedom space, but then on LGBT issues, again, the church has significant disagreements with claims of LGBT advocates around sexuality, gender, but has sought to find common ground and peaceful pluralism. And that, I think, more than anything else, is the model, right, that people ought to be proud of. Not just in Utah, but around the country. And by the way, all the other religious groups that I mentioned earlier and some that I didn't mention have really stepped into this and led in a great way too. But those of you who are Latter-day Saints ought to feel proud of your church, I think.
Could I just add one point to that, to Tim's point about the model of legislation and cooperation that's reflected here? I think one of the biggest values of the Respect for Marriage Act, and perhaps it's the most important long-term protection that it offers for religious liberty, is that it's now established what I think can be characterized as a legislative best practice, right? I mean, I thought the Utah Compromise was wise and sensible, but it was just Utah, right? I mean, now you have the legislative body that is the 900-pound gorilla in the world that has adopted, at least for this legislation, the basic idea that if you're going to legislate about LGBT issues, you also have to be sensitive to religious liberty concerns, and you have to do those two things in tandem. Now, that's a model that people of faith can now take to every town council, and every state legislature in the United States and legislatures around the world, and say, look, the U.S. Congress in this legislation has established this best practice, and this is what you ought to follow. You shouldn't be legislating on LGBT issues unless you're also going to be sensitive to the religious liberty issues that kind of legislation may well create. Right, and so that I think is a long-term benefit that if we continue to use it and press it, will perhaps be the most important outcome of this this exercise, as important as I think the specific protections are.
Excellent, thank you so much. Your turn for questions. Right here, please.
Just without the microphone?
Yeah, we're small enough.
I'll repeat the question. Okay, very good.
Thank you very much. My question is mostly probably for Tim. I'm Anna Seneva. I do public policy and government relations with the Church of Scientology and National Affairs Office in D.C. And I've known Tim since he announced that he is doing the First Amendment partnership thing, so 10 years. My question is, what's next on public policy front for that? Because I feel like both you and Tyler touched upon a very important point, that there seems to be a vested interest always in keeping this radicalization of two polar opposites, because you can fundraise this way better and make it into a campaign, but then you guys managed to do this phenomenal work of finding common grounds and pushing it through regardless of anything. There's so many other controversial aspects where there isn't currently an agreement. What would you suggest on how to proceed with all of that?
So I'm supposed to repeat the question, and
I can summarize.
but no, you can't. Well, okay, you do that.
Yeah,
You
she
summarize the
said,
question.
what's next for this effort? And so I would say that what we have done with the left, center right, is we've created a kind of sanity caucus on LGBT issues. And that then is going to have permutations. First, I think, in state policy. Some of these issues are going to move to state legislatures for a while. But then eventually, I think Congress is going to once again have an appetite and the kind of a political alignment to tackle these issues again. And as Gene said, I'm confident that the combination of a kind of center-left, center-right sanity caucus, coupled with a fresh or pretty fresh legislative precedent or best practice, means that the next time these issues are engaged again at the federal level, they will be in that kind of what I'd call both and win-win fairness for all model.
Anything, Tyler?
I think that's it.
Okay. Next question, please. Yes, sir.
Matthew Brogdon from the Center for Constitutional Studies. My question has to do with Section 6, which uses very direct sort of unqualified language that nonprofit religious organizations shall not be required to provide services, accommodations, etc. Will this run into, if applied to state and local policy, that is to counteract, say, local and state LGBT rights, will it run into the same roadblock that RFRA did in Bernie? Or is there some reason you see this surviving? That kind of, I assume 14th Amendment enforcement clause challenge.
So, you want to take that again?
So the question for Matthew is this is pretty bold language. Are you going to have problems to the degree that this conflicts with state laws that are different? Usually we would say blue state laws. So Matthew, the answer is this does not attempt to preempt state laws to the contrary. Okay, that would have been a really impossible lift. And so all it does is, I think, as Gene says, establishes a legislative best practice and does establish a kind of sense of the Congress that this is not like race or racism. So that's what's really at issue in a lot of the litigation that ultimately arises under state law is you'll have litigation with that is the premise from many progressives. And so this doesn't attempt to preempt state laws. It just establishes a national legislative best practice, I think, that could be cited in all federal law conflicts, and then can be cited in some state litigation. Gene, is anything to add to that?
Yeah, and I would just add that I think if you look at the language of the provision, it does, as just according to a plain reading of it, it would seem to override any federal or state or local requirements along those lines, and it wouldn't surprise me if it's not invoked for that purpose. And, it's true that RFRA was invalidated as to the states by the Supreme Court in the City of Bernie case. That was at a time when the Supreme Court was a lot more sensitive to federalism issues, and they are not as sensitive to federalism issues anymore. And so it's entirely possible that they would decide that that Bernie did not prevent the application of this language to a state or a local ordinance. So it'll be interesting to see how it plays out. Yeah.
Yes, please.
I think it was Tim who talked about, maybe Tyler about the service caucus on LGBTQ issues and other state issues. And there's sort of this, maybe a stable coalition, but I'm wondering how all the transgender legislation we're seeing at state level, what effect that's having on the coalition. Is it actually, we're seeing it eroded already?
You want to take this one? Me too.
I'll go first. So the
Yeah.
question is, we've had all this happy talk about how everybody's working together. And what about the transgender issue set? And how does that complexify these coalitions that have been built? Honestly, if the coalitions weren't already built, I think it'd be impossible to build them right now in this environment. because it's so hard, but I think instead, because you now have people who've been working together for 13 years at the oldest. That's kind of, again, here in Utah, it's where this started. If people have been working together for 13 years, you have high trust, high social capital. You're able to talk frankly about these issues. You're able to distinguish perhaps between all of the different sub-issues. Like right whenever we say trans issues, we're really talking about maybe 12 distinct different kinds of issues and questions. Like an easy one for me is like this drag ban in Tennessee that was just ruled unconstitutional by a Trump-appointed judge, right? Like that's maybe on this end of the spectrum of like how to deal with. And then on the other end, of course, you have things like sports, where you're like, well, that looks like a slam dunk maybe going the other way. But you have to find common ground even there. And if we don't, then we're not going to pass anything. I mean, and that is the reality, is that I think Gene made the very accurate point that now we've established a new baseline that you're not going to pass LGBT rights without absolutely wrestling and respecting religious freedom. It goes both ways, though. Like, I don't know right now what federal legislation we would pass to protect religious freedom that wouldn't also have to wrestle with LGBT and T issues. I think the reality is that there are different parts of the trans issue set that go 80-20 in totally opposite ways. Again, like going to drag ban versus sports, like these aren't simple. These are exceedingly complicated issues that only work whenever you have people who trust each other trying to work together to find the policies, and that's going to take years. So that's a medium length answer to your question that I don't exactly know where it all shakes out. I do know that we have people on the LGBT side and the faith side and the overlap who are wrestling with that.
It's a smart question, though, because it shouldn't be lost on anybody that the Respect for Marriage Act was able to skirt these issues because it was about marriage, not about the trans issues. Those issues have changed a lot since the Utah law passed in 2015, right? The claims being made by activists on the left have changed significantly in the last 8 years. And the reaction and sometimes overreaction on the right has also changed. So it's the political context for those issues has changed a great deal, even since the introduction of the Fairness for All Act in 2018. But it's really good when you have really white-hot cultural issues like this to have people who have all this relational capital and have dealt with other really hard issues and pass them in an environment where, you know, culture war issues don't pass the Congress. They just don't. And we just did it. So it's really good. It's really hard, but it's really good that we have this sort of, as I said, sanity caucus that's been working with each other from, you know, between 5 and 13 years, depending on the actors.
I have to add, in 2000, I'm now going back in the time machine in 2010. Like, trust was not high then. People were very angry then, and we built the coalition. I mean, it just started small. So I do think all of this focus has people everybody in this room is probably thinking about trans issues more than they ever thought they would 5 years ago. And yet, I think there's some good solutions coming out of this. I mean, I hear more conversations now on the secular left than I've ever heard about boyhood and masculinity. And I hear all of these new groups of moms who are fighting for their sons and dads who are fighting for their daughters. And so I think that they're on the back end of this, I think we're going to come up with very fair policy solutions for trans people, and also come to some sort of a social reckoning around sex and gender that's probably been a long time coming, probably ever since like the 1960s. But I love this question because it's why we have to find some common ground. It doesn't work. It's not going to work for Tennessee to pass a drag ban and say like, oh, like we did anything. No, they did nothing. It was struck down as unconstitutional by a Trump-appointed judge. But like the same thing's now going to happen in Vermont and Oregon in a total inverse. And that's going to do nothing for trans people. By the way, no trans person is asking for them to take away parental rights in California. Like actual trans people do not want that, just to be clear. I think actual Christian conservatives don't need a drag ban in Nashville. I mean, maybe in some of the rural counties, like kind of where I live, but not in Nashville, not on Beale Street in Memphis. And so, look, like there's going to be a reckoning. And I think that that's what happened here again with the RMA. Like people at the table are going to write that policy. And we have to hope that the people who are at that table do have high trust, have some expert lawyers who can help write something that can be durable for generations.
Thank you. Okay, we do have time for one last question. Hannah.
Could you speak to the individual protections and then also what wasn't included in the bill that religious liberty advocates and would be included?
I was going to ask him the same things.
Well, personally, yeah. The question concerns individual protections and what was not included in the bill that would have been nice to include, that would have made it, at least in my view, a home run or a grand slam. I really have a lot of sympathy for wedding vendors, people like Jack Smith and the woman who runs who was the subject of the Masterpiece Cake Shop case, and the woman whose case is before the Supreme Court right now in the 303 Creative case. She's a website designer. She's a very sincere evangelical Christian, and for her having to create a website to celebrate a same-sex marriage is religiously offensive. And folks like Tyler are not going to go to somebody like that and say, we insist that you make a website for us, right? I mean, but there are people who do that, and there are governments like the government of Colorado that will persecute people who have small businesses like that, who want to adhere to their religious beliefs. And I think, a home run for me would have been a law that deals with that wedding vendor situation, which is not dealt with in the Respect for Marriage Act, but it does, as I mentioned earlier, it protects individual rights in many of the same ways that it protects institutional rights. Just one example, and I had about 6 examples that we could go through, but just one example that is maybe of greatest relevance here at a university. So, suppose that a future president or a present president or Secretary of Education decides, well, we're not going to provide Pell Grants or guaranteed student loans for students who choose to attend non-affirming colleges and universities anymore. Okay? So those are just off the table now for students at BYU and a host of other religious colleges. Well, the Respect for Marriage Act, that provision that we looked at earlier, Section 7A, protects against that kind of behavior by the federal government. And that, I think, is a pretty significant protection for individuals. The federal government cannot tell an individual, we're going to deny you some benefit that you would otherwise have been entitled to simply because of your own personal beliefs and practices about marriage, or because you affiliate with an institution that has beliefs and practices on that subject.
3 minutes left, 1 minute each. Anything?
Or another question.
Yeah.
Okay.
Yeah. Why don't we take another question?
Or we can vamp.
Steve.
In the interim, you skipped over kind of years 2016 to 2022.
Yeah.
I was really amazed with the work of, actually, I'll let you talk to this. The work to do the Fairness for All legislation, hammering out all the details.
Yeah.
What could the plan be for our T brothers and sisters going forward now for the next 5 years with this trust of that group?
So it's also kind of I would have a cheeky answer to Hannah of like what was missing from the RMA is like, well, the rest of Fairness for All. Like we have this whole big bill that we've written that would be like, truly, we went through all of the federal code and found everything that might possibly need to be updated to protect LGBT people and religious freedom. And so there is that comprehensive bill. And we did, I did actually float it a couple times with the Republicans and the Democrats. I was like, what, we could add employment, like we could add housing, and I was just shot down. So that's what's still out there. And the truth is a lot of it's been written. And the core remains of like what transgender Americans need are jobs and homes. And it would shock you how much discrimination that fully transitioned transgender adults who are hurting no one, who are causing no controversy, how much discrimination they still face. Okay? It would shock you. So then of course we get into all of these other edge cases and things that are happening with kids and like all of the other stuff. But at the core of this, there are transitioned, transgender, adult Americans who are good tax-paying people who need jobs and homes. We've still got to do that. But we do need to lead the way, Steve, in answering the questions that are being brought up in the broader culture around sports, around access to, single-sex spaces like gyms, like salons. These are all things that we have to wrestle with. And the truth is I think that the Fairness for All Coalition has matured to the point, and having won now on the Respect for Marriage Act, has some of the capital on both sides of the aisle to look forward in that. But I don't think it's happening quickly. I think that might be a 5-10 year type project. And that's what it took, though, to do Fairness for All in the first place. And so why should that be surprising? It took that long to figure out how to handle employment. It's probably going to take that long to figure out, to the extent that the federal government should have a role, and maybe this is what will save us some time, is like some of these issues, federal government really is not going to have a policy, but we might need to have Congress say so. And so there's just a lot. That'll be the next panel. That's next year.
I would just add there were proposals from some conservative senators who did not like the RMA to add additional religious protections, which I would in a vacuum support, right? They are essentially the rest of the Fairness for All Act. They're like if we could just write the bill without any political anybody on the other side opposing us, what would we write? There was stuff like that floating around.
Senator Lee had some great suggestions and proposals.
Yeah, they're great suggestions. Here's the thing, though. Realistically, when deals are done in any legislature in any bipartisan way, you never have a 99-to-1 deal, right? Those proposals were 99 religious freedom, 1 gay rights. That's what they were, right? And so everybody understood them inside of the Congress as to be attempts to kill the Respect for Marriage Act. Respectfully, the people that were proposing those things, all of their colleagues knew they were trying to kill the the Respect for Marriage Act, not pass these religious protections. Okay, when you're gonna get a deal done in the Congress, it's a 70-30 deal, it's an 80-20 deal. I think this is like a 75-25 deal for religious freedom. You don't get 99-to-1 deals, and if you insist on 99-to-1 deals, there's going to be no deal.
Thank you very, very much. And I hope now you will join me in showing appreciation